I am living flesh and blood human. Government has taken that name and made an all caps name. So it will go to the Supreme Court, I promise you.
You understand that you've been charged in this case with cocaine, heroin, or another narcotic. The maximum penalty for that offense is up to 4 years in prison.
No matter what you do to me, I will get out of it and there will be loss.
Welcome back to the courtroom, folks. Today's case is one that perfectly captures the bizarre clash between sovereign citizen ideology and the reality of criminal law. Our main character here, Robert Mattson, isn't just fighting charges of narcotics possession. He's fighting the entire concept of government authority. From the jump, he insists that his all-caps name isn't really him, that the legal system has no hold over his flesh and blood identity, and that he's going to the Supreme Court if necessary. Sounds wild, right? Well, stick around, because it gets even stranger. You'll see a patient but firm judge, a prosecutor trying to keep things grounded, and a defendant who seems convinced he's uncovered a secret legal loophole that will set him free. Spoiler alert, these arguments have been tried hundreds of times across U.S. courts, and not once have they worked. But the real drama here is in the delivery. Watch closely to see how Mattson presents his case with total confidence, as if saying it loud enough makes it true. By the end, you'll be asking yourself, does he actually believe this stuff? Or is he just trying to delay the inevitable? Let's dive in.
First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir for the people.
Phoebe Muir on behalf of the people.
James Daly on behalf of the defendant.
All right. And
I never asked for an attorney. I said I would be representing myself in appropriate persona. This is just one way to railroad me. That's all. Get me in your jurisdiction.
All right. Mr. Daly, maybe you or Ms. Muir, maybe you can fill me in on the status of the...
Yes, Your Honor. I remember now. We did have an exam in this matter, and Mr. Mattson did represent himself at the preliminary exam. And then Mr. Mattson, then once it was bound over, did fail to appear here in circuit court. So now that he is incarcerated, whereas before he was not, I guess if we just go through whether or not he wants an attorney or still wants to represent himself, since we have had an exam in this matter, once he makes his intentions known on the record, then we can proceed with him still being pro per. But I would like to go through and make sure he is knowingly making that decision.
All right.
I normally am.
Okay. Yeah, Mr. Mattson, just let me sort this out a little bit. Mr. Daly, have you been appointed as standby, or what exactly is your status?
I was appointed as standby, Your Honor. Mr. Mattson and we get along fine. He's a pleasant individual to talk to, but he wants absolutely none of my legal input. Basically, he has a theory that I don't believe is justified under the laws of the state of Michigan.
Okay.
And I've indicated that to him.
All right. We are back on the record then in the matter of People versus Robert Mattson. Sir, you are Robert Joseph Mattson, correct?
I am an attorney for the all caps name Robert Joseph Mattson. I am living flesh and blood human. Upper and lowercase Robert hyphen Joseph :space Mattson. That is my name.
All right.
As shown on my birth certificate, live birth, that would be me, as understood that the government has taken that name and made an all caps name and tried to be to claim an account over that name, which to do business with.
And there it is, the classic sovereign citizen setup. The defendant rejects his court-appointed lawyer, insisting he'll go in propria persona, which basically means representing himself. The issue? Courts have seen this tactic time and time again, and it almost never ends well. Judges are very careful in these moments. They want to be 100% sure the defendant understands the risks before they waive counsel. That's why you'll see the judge here double check, triple check, and put it all on the record. If Mattson messes up, and trust me, he will, he won't be able to claim later that he didn't know what he was doing.
Sir, do you understand that you have a right to be represented by an attorney in this matter?
I do understand that.
Do you also understand that if you want an attorney and you can't afford one, that you can tell me that and I would appoint one for you at public expense?
UCC 1-308, all rights reserved. By me answering and speaking to you at this time doesn't mean that I'm in any way being given any kind of authority over my body to you at this time.
Okay,
Your Honor.
I will note, sir, your objection to my jurisdiction over you, and I will preserve that for the record. As
Your Honor,
discussed in your hearing on Monday, it is my position that this court does have jurisdiction over you, and I am going to proceed as such. And
yes, sir.
Again, your objection is preserved for the record, and if you would like to file an appeal, if that becomes necessary at a later date, you'll have the ability to do that.
Actually, I think I can do something a little quicker. I like to exercise my rights of subrogation, have the prosecutor file my right to subrogation, or certify my right to subrogation at this time. It's an undeniable right. Subrogation is the removal of a third party. It's in the laws, Black Laws Dictionary, 6th edition. Also the Bluebeard Law Dictionary, 2nd edition. That the removal of third party would be the prosecutor in this case.
All right. I'll note that request for the record and find that there is no right to subrogation in a criminal matter, and so I'm going to deny that request. Again, your objection will be noted for the record, and if you feel you need to appeal that decision at a later date, you will have the ability to do that. You understand, sir? You understand, sir? That you understand, sir? Sir, please let me speak. Do you understand, as I asked earlier, that if you can't afford an attorney and you want one, that the court would appoint one for you at public expense?
Do not want one. Thank you.
Okay.
I am not a U.S. citizen. I am sovereign. Separated myself from the U.S. government back in 2018.
We've covered that objection, Mr. Mattson, and I've ruled on it. Again, it's preserved for the record, and you can appeal it to the Michigan Court of Appeals if you would like.
This right here is sovereign citizen performance art at its finest. The obsession with punctuation, capitalization, and hyphenation isn't random. It's part of a fringe belief that playing with the format of your name can somehow separate you from government control. The theory is that your legal name is a corporate entity created by the state, and the real you is beyond their jurisdiction. Courts, of course, don't buy it. To them, whether your name is in all caps or bubble letters, if you're the one sitting in front of the judge, you're the defendant. Period.
Definitely, it's fraud. American jurisprudence guaranteed fraud. I studied it up and down. I know it all too well. So it will go to the Supreme Court. I promise you.
Okay.
As of right now, I would, for the record, and let the record reflect any objections or denials that you keep denying me, that I'm asking you to file a 1090 an OID 1099 for the prosecutor, because the prosecutor is using my name to do business, and I will prepare the 1096 and the 1099A. So this court proceeding is going to go on and have a jury trial, is going to be sovereign people, secure party creditors at my status, and also he's going to be filing that OID 1099 for the prosecutor.
Right, sir, do you understand that you've been charged with possession of a controlled substance in this case, and that the maximum penalty
I don't
for that
understand the
offense?
nature of the claim.
Sir, I'm going to ask you to let me finish when I'm speaking. I've done the same for you, and I'd ask you to do the same for me.
Your Honor. Yes, sir.
You understand that you've been charged in this case with possession of a controlled substance, cocaine, heroin, or another narcotic of less than 25 grams, that the maximum penalty for that offense is up to 4 years in prison.
I do not understand the nature and the cause of the crime.
All right, I'm advising you at this point that you have been charged with possession of a controlled substance, cocaine, heroin, or another narcotic of less than 25 grams, and that the maximum penalty for that offense is up to 4 years in prison. I'm also advising you that you've been charged with operating on a suspended license. A license has been suspended, revoked, or denied, that there is a second offense notice with that, and therefore the maximum penalty for that offense is up to 1 year in jail and or a $1,000 fine. I'm also advising you that you have been charged in this case with alcohol, open container in a vehicle, and the maximum penalty for that offense is up to 90 days in jail. This also carries a habitual offender second offense notice, which increases the potential penalty to 1.5 times the maximum sentence on the primary offense.
Here we go again, another made-up loophole. He's demanding subrogation, but here's the kicker. Subrogation is an insurance term, not a criminal defense strategy. It refers to one party stepping into the shoes of another to recover a debt, like when your insurance company pays a claim and then sues the person responsible. It has absolutely nothing to do with criminal charges. But in sovereign citizen circles, words like this are thrown around to sound impressive. The judge knows better, though. You'll notice how calmly he shuts it down and moves on without breaking stride.
You do have the opportunity to consult with a lawyer if you wanted one, and if you can't afford one, I would appoint one for you at public expense. Mr. Manson, or sir, I believe you've referenced this already, but do you have any training in the law?
Yes, I do.
Would you tell me just a little bit what that training is?
Common law.
Okay, and have you studied that yourself?
Yes, I have, along with a couple other people.
Okay, you understand that the law in this case consists of criminal statutes that you're alleged to violate, the Michigan Court Rules of Criminal Procedure, Michigan Court Rules on Evidence, and any number of decisions from the Michigan Supreme Court and Court of Appeals which interpret those statutes and rules.
I understand that the Michigan Supreme Court offers two different types of courts. Common law court and a tribunal military maritime court, which this court is operating under, and they're not operating properly with me at this time.
Right, you understand that the prosecutor
Sorry, go ahead.
You understand that the prosecutor that's going to try this case has been to law school, has had significant education and a number of years of experience and training in the law.
And that's perfectly fine.
All right. Do you understand that if you do represent yourself, you're going to be required to follow the Michigan Court Rules and the Rules of Evidence?
I'm going to be operating under common law laws, which that's what I should be under as common law. If this is not a common law court, I don't belong here.
All right. You understand that I know you've made that objection and then made it several times, but I'm going to conduct a trial on this matter that's going to require you to follow the Michigan Court Rules and the Michigan Rules of Evidence. You understand that?
Yes, sir.
And you understand that those rules are going to determine whether you can do things like ask certain questions of witnesses, admit documents, photographs, or any other evidence that you might have.
Yes, sir.
You understand that you're going to be responsible for the jury selection process, and that's also governed by court rules, which determine when you can appropriately challenge a witness.
Yes, sir.
Do you understand that in order to become a licensed attorney to practice in Michigan, it typically requires at least 3 years of law school and passing a bar exam to show that you have a sufficient knowledge to work as an attorney?
Not a part of the state of Michigan. I am the Republic of Michigan, Michigan Republic.
Okay, do you understand that in order, if you wanted to have a license to practice law in Michigan, you would need to go to law school and pass the bar exam?
This is the moment of reality check. For all the theatrics, the judge calmly lays out the charges. Possession of cocaine or heroin under 25 grams, operating on a suspended license, and open container in a vehicle. Add in a habitual offender notice, and the sentence could stack up quickly. And here's where the defendant's behavior really clashes with the stakes. He's cracking sovereign citizen lines while facing years in prison. Notice his body language, too. Fidgeting, jaw clenching, nervous pauses. Deep down, he knows this isn't a game.
That the attorney's handling your case, the prosecutor is going to have a license to practice law in Michigan that meets the requirements that I've already indicated to you.
Which makes any judge or prosecutor or attorney a part of Great Britain, foreigners, only operating under the foreign sovereign immunity, which actually I have myself and trumps over all years.
All right. I appreciate your objection to this court's jurisdiction, and I've ruled on that. And again, I'm not going to change the ruling. You can appeal that to the Court of Appeals in the Supreme Court if you wish at the appropriate time.
Do that.
Do you understand that?
Definitely.
At least in my opinion, I think you're going to be at a significant disadvantage in this case if you attempt to represent yourself with having a licensed attorney on the other side.
I already am. I'm dealing with the wolves. There's no fair trial in this military maritime courts. There's nothing fair about it. I mean, you've already made your determination the other day that I was not guilty. Last time I seen you in court. Let the record reflect that. I mean, you sit there and enter the plea and not guilty.
Sir, as I indicated to you at that hearing, I entered a not guilty plea for you. That is not my determination that you are not guilty of what's been alleged.
It's working from the bench, Your Honor. It's not your job to enter a plea. It's mine or my attorney's, which in this case it would be mine. So the court has already made a determination that I am not guilty.
All right. Sir, are you sure that you want to represent yourself knowing all of the disadvantages, or at least what I believe to be the disadvantages that you face?
Yes.
And is that decision absolute and unequivocal?
Absolute and unequivocal.
Do you have any